People tend to lose or rather be irresponsible about the things that they say or post. So today's conversation really relates around how you conduct yourself on social media, and most importantly, I mean, how that really impacts you within your business or the company that you may represent. You know what I mean? Yes. So I'm quite excited about that. I mean, let's talk about just the importance of it. You know, what's that about? I mean, bringing a company into Disrepute, what does that really mean?
So I think bringing the company's name into disrepute is essentially any conduct, whether it's on duty, off duty, that impacts the company's image, reputation, or brand as a whole.
Okay. Hectic stuff. So what sort of crimes, quote unquote, or rather, actions would one consider as bringing a company's name into disrepute?
Yeah, Tubbs, I think these days, in the era of social media, there's so many examples we can use. I refer to it as modern day misconduct, where social media, you are out there, your name is out there, and also which company you work for is often out there. I think the majority of individuals at least have the company they work for on their Facebook or on LinkedIn, whatever the case may be. So what that does is that automatically connects you to your company online. And if you conduct yourself in a way, like I said, whether it's at work or outside of work, that impacts the company's image, that can be seen as misconduct within the workplace. And the company has the right to take action against you for that.
Hectic stuff. Now, how does this really tie into be it with a labor law that is presented to all entities, or just general rules and regulations, or a conduct that is presented by the company? I mean, they must differ, and there must be a discrepancy between the two, of course. I mean, how does one really find a balance between that?
So at the end of the day, you need to look at first of all, what the conduct was that the employee committed. Okay. Is it the type of conduct that you wouldn't want your company to be associated with? So the example that I'm sure everybody's aware of, last year in July, I believe it was, there was an incident at a Coldplay concert where two very senior employees of an organization were caught on a camera there, and they were getting a bit too comfortable. They both had families and things like that, and they were obviously linked to their company on social media. Sure. So when that blew up worldwide, obviously it was within minutes that they could trace these two individuals to the company, and especially with senior employees, there's a duty on senior employees to uphold the image of the company and the reputation and the values, essentially. So, them being in both committed relationships and then getting a bit too close for comfort in the public eye, that was a clear kind of violation of what the company would like to portray as their value. And I think in that instance, both parties elected to leave the company voluntarily. But in the case where an employee, let's say, doesn't want to leave voluntarily, the company does have the right to take disciplinary action against them, obviously following the correct procedures, whether that be a disciplinary hearing or whatever the case may be, and they can eventually be dismissed if the conduct is serious enough, and if the damage to the company's name is that of a serious nature.
That is hectic. Okay, so I'd like to give you a different scenario, a different example. So here we are, it's December, we've had a couple of a bit of liquid motivation, you know what I mean? And you find that, you're with colleagues and perhaps you say something that is, let's say, derogatory, for a lack of a better word, How is that seen, from a putting a company's name into disrepute point of view, in the sense where, a colleague would hear you saying, I hate working for this place, you know what I mean? And maybe just said in passing and not necessarily with ill intent. You know what I mean?
Yes.
Yeah.
So at the end of the day, the conduct can be intentional or unintentional, direct or indirect damage to the company's reputation. So an example like that, you need to be very careful as an employee. If you're speaking loosely and openly, often as you do after you've had a few drinks, that there might be individuals, let's say a customer of your company that you work for, a supplier, in some way related to them. And if they hear you talk talking in a derogative manner about your company or your manager, for example, or the working conditions, that might shed a bad light on the company. And that supplier or that customer might have then a different view and maybe not go to your company for their services or their products anymore. So I think the general principle is that if you do connect yourself to the company, whether that be through social media, whether that be you wearing your company uniform outside of working hours, if you are connecting yourself to your company, if there's a nexus between yourself and the company, you really need to be careful with the way you conduct yourself.
Okay. Hectic stuff. Now, with that said, though, I mean, how do we sort of find a balance, especially when it comes to what is deemed as hearsay, in the sense where, considering that in this instance there was a bit of, or people were under the influence at that stage, how does one really then find that balance to find someone actually guilty in such a situation?
Yeah, that's a great question, Tubbs. So at the end of the day, employees are always entitled to a fair procedure. So let's say that this incident that you've explained now comes to light to the company. They're under obligation to follow a disciplinary process, which generally finds the form of a hearing. And in that hearing, the employee has the opportunity to defend themselves, to submit evidence, and the company has the obligation to prove that that misconduct happened. So if the company can call witnesses to testify to this is what the employee said, this is how it was said, this is what we perceived, and those witnesses are found to be credible versus what the employee has presented in terms of evidence, then on a balance of probabilities, the employee is most likely guilty. And within the scope of labour law, the balance of probabilities is the threshold that we look for in terms of guilt. It's not beyond reasonable doubt. That's in the criminal court. So in that disciplinary hearing, if the chairperson finds on a balance of probabilities that that is the most likely situation or thing that happened or what was said, then they will be found guilty. But it's very important that there is evidence to substantiate that. You can't simply say that I've heard this thing happened without being able to substantiate it with evidence.
Sure, that is hectic. So I think the top tip then for today is be very particular about what you put on social media or what you say in public generally.
100%.
Wow.
I would say if you choose to associate yourself with your company, which is great, if you're proud of who you work for and you put it out there, that's great. But then I think you just need to know that there's that weight on your shoulders that you have to conduct yourself with the values of the company and not in any way that would damage the company's reputation.
I see. Now, my very last incident for you before I let you go, my good sir, is a similar situation where, say, for example, you find yourself in an altercation not related to the business in any way or form. So, as maybe one of the most easiest examples would be maybe a spate of road rage. You're driving, someone cuts you off, you lose your mind because naturally they put you in a situation of danger, but not realizing that you're actually dressed in your uniform, and here you go and you lose your mind and find yourself in a sticky situation. I mean, what would that really look like?
Yeah, so once again, the fact that in your example you have your work uniform on automatically connects you to your company. So in that case, you should rather, as hard as it is sometimes,
take it
off. Stay in the car. Don't do that. Because you're going to find yourself in a bit of trouble, especially these days. Everybody's got dash cams. Everybody's whips their phone out when something happens. Quick. So it's modern day misconduct is very prevalent.
Hectic stuff, man. Oh man. So rather just breathe in, breathe out, keep driving. That's all it is.
Exactly.
Hectic stuff, man. I love it, my good sir. Now let's talk about you again, just with the role that you do, and most importantly, some of the services that you guys would render as a LabourNet. Yeah,
so LabourNet is a full HR compliance company, so we offer employers full HR compliance. From my side, we do labour law, but we also offer health and safety, information compliance, transformation, a whole bouquet of products that employers can make use of to make sure that they're compliant within the HR and broader space.
I love it, my good sir. And if people want to reach out to you and most importantly then acquire the wealth of knowledge that you are, my good sir, how do we do that?
Yes, so everyone can check us out on all the main socials. LabourNet is most active on LinkedIn, so you can check us out there. We've got a website, www.labournet.com, and if anybody wants to reach out to me directly, they can email me. My email address is mdenny, that's mdenny @labournet.com.
Awesome stuff. Mike, thanks so much for joining us this evening, sharing some great insights, man, on bringing a company into disrepute and how you need to handle yourself, be it whether on social media or alternatively, in the general public at large.
Perfect.